Hi, everybody, and welcome to My HR Council's FMLA Basics, What Every Employer Should Know webinar. With us today is Brittany Nichols. She is one of our senior attorneys with My HR Council. Normally, she works remotely, so we're very lucky to have her with us today in the office. And I will also be presenting. My name is Janelle Stanton. I'm the Director of Communications for My HR Council. Today, we are going to be going over some of the basics of the FMLA. Unfortunately, this is a very complicated law. It seems straightforward, but the actual application of it is much more in-depth and would require a couple of days seminar to cover appropriately. So what we're going to be doing today is really more of an overview, touching on the basics, notice requirements, certifications, reinstatement, because FMLA is job protected leave, and then we'll also be discussing the intersection of the FMLA with the Americans with Disabilities Act. So first we'll talk about who are covered employers under the FMLA. And so private sector employers who employ 50 or more employees in 20 or more work weeks in the current or previous calendar year are considered covered employers. So when you're looking at who to include as an employee, you must include toward that 50 employee count any employee who works in the United States, any territory or possession of the United States. You have to include any employee whose name appears on payroll records, whether or not any compensation was received for that work week. You have to include employees that are on paid or unpaid leave, which would also include FMLA, any sort of discretionary leave of absence, maybe somebody's on a sabbatical, that employee would count as well. You also have to account for any employee that's on disciplinary suspension. But basically the test is, as long as there's a reasonable expectation that that employee is going to return to active employment, they must also then be counted toward that 50 employee count. You have to count employees of foreign firms that operate in the U.S., and you have to count part-time, temporary, and seasonal employees, as well as obviously full-time employees. Some examples of employees that actually don't need to be included are obviously employees who the employment relationship has ended, such as employees that have been laid off. You don't have to include unpaid volunteers that are not on the payroll. You don't have to count employees of the United States firm stations at work sites outside the U.S. or employees of foreign firms that work outside the U.S. So those are types of employees that actually don't need to be covered toward that 50. Local educational agencies are covered under the FMLA regardless of the number of employees they employ. So that would be public school boards, public elementary and secondary schools, and private elementary and secondary schools. So those are also employers that are covered under the FMLA. Public agencies are covered under the FMLA regardless of the number of employees they employ. Some of those would be the federal government, state government, or political subdivision of a state, and as well as agencies of the U.S., and that term state does include any state within the U.S., the District of Columbia, and a territory of the U.S., so such as Puerto Rico. That would be included in the definition of a state. That would be covered as well.
So next we'll get into who is considered a covered employee. And a covered employee is someone who works for a covered employer that Janelle just went over. And then there are a few other requirements here that you can see on the slide. One being that the employee has worked for the employer for at least 12 months as of the date the FMLA leave is to start. So those 12 months of employment do not have to be consecutive. Part-time, temporary, seasonal work generally counts toward that 12 months of employment. If an employee is maintained on the payroll for any part of a week, that week counts as a week of employment. And so any combination of 52 weeks equals 12 months. So you can see this is a relatively generous rule for employees. If an employee has a break in employment that lasts 7 years or more, the employer is not required to count the time worked prior to the break unless that break in employment is due to service covered by USERRA, which is Uniformed Services Employment and Reemployment Rights Act, so someone in the military, or if there's a written agreement, including a collective bargaining agreement that outlines the employer's intention to rehire the employee after a break in employment, or if an employer voluntarily considers periods of employment prior to a break of more than 7 years. But if an employer does that, they have to do it uniformly for all employees with similar breaks in employment. The next requirement to be a covered employee is someone who has at least 1,250 hours of service for the employer during the 12-month period immediately before the date the FMLA leave is to start. And you'll note here there's a different requirement that applies to airline flight crew employees. There are special rules actually that apply generally to flight personnel as well as to public agency and school employees. So those are a bit different. But generally speaking, with respect to those hours of service requirement, those are met if the employee has worked a total of 1,250 hours of service in 12 months just before starting FMLA leave. And this averages out to a little more than 24 hours of work a week in the 12-month period. Time that's not actually worked, including vacation, personal leave, sick leave, holidays, and any other form of PTO is not counted towards the 1,250 hours of service. And unpaid leave of any kind or periods of layoff are also not counted. An employee who's returning from fulfilling a USERRA-covered military service obligation is actually then credited with the hours of service that would have been performed but for the period of military service. So there is a little bit of an exception for that type of leave. And then the final requirement here is an employee who works at a location where the employer employs at least 50 employees within 75 miles of that work site as of the date the employee gives notice for the need for FMLA leave. So that number is determined based on the number of employees on payroll, regardless of whether they are part-time, temporary, or seasonal employees. And the 75 miles are measured from the employee's work site by surface miles. So using surface transportation over public streets, roads, highways, and waterways by the shortest route possible. And the work site is ordinarily the site the employee reports to or from which the employee's work is assigned. A work site can refer to a single location. It can be a group of buildings, such as a campus or industrial park, or it can refer to separate facilities in a geographic proximity to one another, so it's a bit of a flexible definition there as well. And an employee's personal residence is not considered a work site. So for employees who work from home under telework or flexi-place arrangements, or other employees such as salespeople who may leave to work from and return to their own residence, the work site is the office to which they report or from which they receive assignments. And for employees with no fixed work site, like construction workers, transportation workers, some airline flight crew, the site to which they report or from which their work is assigned, or the location to which they are assigned as their home base, will be considered the work site.
So this is going to cover what type of leaves are covered by the FMLA. As you heard from Britt's last slide here, these all are sort of seemingly simple requirements. You've heard 1,250 hours, 50 employees within 75 miles, but there's a litany of other smaller specifics that you have to comply with. It's really no different with the covered leave. So, one of the reasons for covered leave is the birth or adoption of a child. This can also include the placement of a child for foster care or adoption as well, which is something that a lot of employers don't think about. An employee's serious health condition is an FMLA covered type of leave. Serious medical condition, basically the definition is that it makes the employee unable to perform the functions of his or her job, including incapacity due to pregnancy or for prenatal medical care, so before the baby comes. If a expecting mother is having complications, that can qualify her to receive FMLA leave as well. A serious health condition is considered an illness, injury, impairment, or physical or mental condition that involves inpatient care or continuing treatment by a healthcare provider. So it's not necessarily I sprained my ankle and I went to the doctor once and I can, I'm just kind of sitting at home. It has to actually be some type of inpatient care, continuing ongoing treatment. So that history of treatment is really important. The FMLA doesn't apply to those routine medical examinations, such as the physical. It doesn't apply to common medical conditions like, I'm home today because I've got an upset stomach. Unless there's some other type of complication that develops, that's not necessarily going to be considered qualifying under the FMLA. FMLA also covers a family member's serious health condition. This can include a spouse, a parent, not an in-law, and a son or a daughter, also not an in-law. So if you have a family member that is suffering from a serious health condition, that could be an FMLA qualifying leave. And the last type is a qualifying exigency leave. So this would be referred to as military caregiver leave. And this is a really unique sort of brand of FMLA leave. It gives actually 26 work weeks of leave in a single 12-month period to care for a covered service member who has suffered a serious injury or illness. As long as that employee is the spouse, son, daughter, parent, or next of kin of that service member, an employee may qualify for 26 work weeks of leave to care for that service member. All right, so the next topic that we're going to talk about is notice requirements under the FMLA. There's a number of things that employers should keep in mind here. So the first is workplace posting. Every employer that's covered by the FMLA is required to post and keep posted the FMLA notice. It has to be posted on its premises in a conspicuous place like a lunch or a break room. It needs to be somewhere where it can also be seen by applicants, which is can be sort of difficult if you have an applicant come in and they sit in a conference room and then they leave. You may not be catching all of your applicants with that notice. And it's got to be displayed prominently. It can't be in a manager's office where employees don't typically go. The poster and the text have to be large enough to easily read, and they've got to be fully legible. So if it's something that you print off and your printer is kind of out of toner and some of it's not clearly legible, you would need to make sure to reprint that in something of a higher quality. You also need to, if you're an employer that has a significant portion of workers who are not literate in English, the employer must provide that notice in a language in which those employees are literate. And I know the Wage and Hour Division, they have a poster in English and Spanish that's available, but for example, if you are an employer that has a large employee workforce that is Hmong, or Somali, you may need to contract through and pay for a poster in those languages. You have to post this, and this is something that's surprising for employers, but you have to post this notice even if there's no employees that are eligible for FMLA leave. If you are covered, if you have the 50 employees within the 75-mile radius, and you are, one of those private sector employees or employers, or one of those, covered employers, you do have to still post that. And electronic posting is permissible as long as it complies with all of the requirements of the notice under FMLA. If an employer has any eligible employees, it has to also include a written FMLA notice in the employee handbook or some other type of written guidance. So if you are an employer that doesn't typically provide an employee handbook, talk to us, because you definitely should have an employee handbook. But if you don't, we recommend that you distribute a copy of a general notice, like what we talked about above, to all of your workforce. Make sure they get a copy of that. And electronic distribution is sufficient, but handbook really is the best. The handbook should specify which 12-month period is to be used, whether it's the calendar year, the rolling method. You should describe how the FMLA will work with other leave policies. Like if you have a PTO or sick leave policy, will that run, concurrently with FMLA time? You should also spell out how employees should provide notice of the need for leave, as well as whether the employer will require a fitness for duty certification, what happens to benefits, and the increments in which leave may be taken. And the reason you want to comply with this is the consequences of failing to follow these notice requirements can be dire. If an employer fails to comply with the posting and notice requirements, that employer can't later discipline or terminate an employee who fails to provide the necessary notice of need for leave. So that's a huge consequence. You could potentially be wrongfully terminating employees if they fail to provide that notice. It can also constitute interference with, restraint, or denial of FMLA rights, which is actionable by the employee. And we're not talking, like a couple of $100 settlement here. These can be, depending on how pervasive and severe the interference is, these could be, lawsuits in the hundreds of thousands of dollar range. So it's really not something that you want to be toying around with. You want to make sure you're making all these workplace postings. The employer can also be liable for any compensation and benefits that are lost by reason of a violation of the FMLA. So civil penalties can be up to $110 for each willful violation of the law. So again, it's a really serious, something that's really serious and needs to be taken into account. So one of the things you just heard me talk about is that an employee handbook should specify which 12-month period is used. So there's 4 options that employers have in setting up what they're going to use for their 12-month period. You must carve this out and stay consistent with it. So the first option is a calendar year, so just January 1st to December 31st. You could use your fiscal period, your fiscal year, so any 12-month period. If you want to do April 1st to March 31st, just because you can. The other options are the rolling method. So a fixed 12-month period measured forward from the date of any employee's first FMLA leave. So if they, start FMLA on April 1st, in that 12-month rolling forward from April 1st, they get the 12 weeks. And the second method is a fixed 12-month period measured backward. So measuring, backward instead of forward with the other issue or with the other method. So one of the issues is the issue of stacking. So leave stacking occurs when an employee uses his or her 12-week leave entitlement at the tail end of one 12-month period. and then becomes entitled to another 12-week leave entitlement at the beginning of the next 12-month period. So if, for example, your calendar year runs January 1st through December 31st, and you have an employee use 12 weeks at the very tail end of the year, on January 1st, they're entitled to then another 12 weeks. So you could end up with an employee out for 24 weeks. Or if you have an employee that qualifies under the qualified exigency type of leave for service members, you've got 26 and 26 weeks. I mean, that can cause serious disruptions in, an employer's personnel and workforce arrangement. So we really try to have our clients steer away from those calendar years or the fixed year and use the rolling 12-month period. It just precludes the possibility of that type of disruptive stacking. So the 12-month rolling period, it definitely does have the most advantages in terms of workforce management, but it does require some pretty meticulous record keeping, and it is definitely more challenging to administer. All right, so moving on, we'll start talking about what is required as far as employee notification. So the first thing to make everybody aware of is there are no magic words. An employee does not need to come in and say, "Hi, I need to have surgery. I would like FMLA leave, please." They're not required to give that level of specificity. If an employer knew or should have known that an employee had an FMLA qualifying illness or injury, you have to go forward with the notice requirements. I've had situations with clients where an employee said, "Hey, I'm having surgery on my shoulder. I'm going to be gone for 4 weeks." The manager did nothing with that information. The employee was out for 4 weeks and came back, and then later had another FMLA issue. And so technically, they had already used 4 weeks of FMLA and were only entitled to the remaining 8 weeks. But because the employer didn't go through the process to designate, we advise, unfortunately, to give those extra 4 weeks. So you want to make sure that if you have reason to know there might be FMLA involved, make sure you follow up on it. And if you're not sure if the employee statements rise to the level of implicating FMLA, ask for additional information. So if the need for leave is foreseeable, the employee has to give at least verbal notice sufficient to make the employer aware that the employee needs FMLA leave. It doesn't, like I said, have to be specifically the words FMLA. If the need for leave is not foreseeable, the employee just has to give enough information so that the employer can determine whether FMLA might apply. So there's not a hard and fast rule here. As far as the timing on employee notification, if the need for leave is foreseeable, such as an employee comes to you and they announce their pregnancy and they say, "Hey, I'm going to need time off after the baby is born," employees are then required to provide notice 30 days before the leave is to commence, if that's foreseeable. But if the need for leave is unforeseeable, employees are required to notify just as soon as practical, but taking into consideration the facts and circumstances of that particular case. And we also recommend, and I talked about this in the handbook section, but make sure that you have spelled out clear requirements for the process employees should follow when requesting any type of leave. The procedure should describe the specific form required in order to make a leave request. So if you have a specific form the employee should use, it should identify the person to whom leave request should be addressed. So if it goes to a direct supervisor, if it goes to HR, if you're a small company, it goes directly to the CEO. Let your employees know who they should request that leave from, and then lay out the consequences for failing to follow that leave. So if an employee fails to report their absence, within X amount of hours at this phone number, that they may be subject to discipline, including and up to termination, depending. But I want to stress here that while you should have clear procedures in place, being overly strict with these rules when there's an emergency situation can get employers in a lot of trouble. As an example, there's a case, and I can't unfortunately remember where it comes out of right now, but the employee was having a severe mental health crisis. She was hospitalized and she couldn't even speak. So her son called in for her instead of the employee and said, my mom is in the hospital, she's having a mental health crisis, she won't be there. Well, this happened for several days where the son continued to call in. The manager who was receiving these phone calls got irritated, said, your mom has to call in, you're not the employee. And when she couldn't call in because she couldn't speak, the employer fired her. In this case, the employee got $400,000 settlement out of this. So you have to make sure that you have rules in place, but be flexible if there are emergency situations. So just like there's employee notification requirements, there are also employer notice requirements under the FMLA. And there's 3 different types of notice that have to be given. And the first one is the eligibility notice. So this has to be provided to an employee within 5 business days of finding out that an employee might be absent for some FMLA qualifying reason. So again, knowing or should have known that the employee was going to have an FMLA absence. The eligibility is determined and has to be provided at the beginning of each instance of leave. So if there's leave in April for one reason for 2 weeks, and then leave in November for some reason for 4 weeks, you have to give an eligibility notice for each reason during that applicable 12-month period. And the notice of eligibility, oddly enough, it can actually be oral or in writing. I would never recommend that an employer provide the eligibility notice orally. You want to make sure that you're documenting that you're providing all of these notices. The second is a notice of rights and responsibilities. So each time that eligibility eligibility notice is given, the employer must also provide a written notice detailing the specific expectations and obligations of the employee. And the Department of Labor actually has a template available online that combines both of those. I like to do it that way just because then you make sure you are hitting both notices right away. And then the last notice is the one that I often see clients miss the most. And this is the one that designates leave as FMLA qualifying. So in all circumstances, it is up to the employer to specifically designate the leave as FMLA qualifying. So if there's enough information for an employer to designate the leave as FMLA qualifying at the time the employee comes to you, give the designation notice right away. You don't always have to seek medical certification. A lot of employers do just as a matter of course, but if the need for leave is obvious, you can certainly designate that right away. If the employer does need additional information, the employer can seek that additional information through a medical certification. There's actually a form online for that as well, so that you can be sure your employee's physician or treating doctor gives all the information that you would need. Typically, an employee has to provide that requested certification within 15 days of the employer request. Again, I caution employers to be very mindful that 15 days, while it is, it is in the statute, you may have situations where there's extenuating circumstances and you've got to extend that 15 days. So, a situation that comes to mind is if you have an employee that needs to get certification from some type of specialist and they can't get in with that specialist for 25 days, but they've got the appointment, be flexible with that 15 days. Most of the time they're going to be able to get it to you within that time frame, but just be mindful of that. And then once the employer has sufficient information, you have to designate within 5 business days. So that's a pretty quick turnaround, but you need to make sure that you are hitting all of your deadlines here. Failure to do so can result in an FMLA interference claim. And as my example for the son calling in for his mom, you definitely don't want to be facing down one of those types of claims.
So as Janelle just went over, employers can request certain certifications from employees. So you can request an employee to submit certification supporting the request for FMLA for the employee's own serious health condition or for the serious health condition of a family member, for military caregiver leave, or for the military family qualifying exigency leave. And as Janelle mentioned, again, the DOL does have a template certification on its website that's very helpful. Employers may also require a fitness for duty certification from employees who are returning from FMLA, although employers should only require the fitness for duty certification if such requirement is uniformly applied to all similarly situated employees. So employees in the same occupation, employees with the same serious health condition, that sort of thing. You don't want to be discriminatory in your application of that requirement for the fitness for duty certification. And if the employer does require fitness for duty certification, the employer must also advise the employee of this requirement in the designation notice and at the beginning of leave that Janelle just went over in the last slide. That designation notice must also advise the employee of any requirement that the certification addresses, that the employee's ability to perform specific essential job functions. If the employer requests a fitness for duty certification, the employee must provide it at the time the employee seeks reinstatement.
Okay, so that actually is a really great segue into talking about reinstatement under the FMLA. As most people are aware, FMLA leave is job protected. So when an employee goes out for some FMLA qualifying reason, those employees are entitled to be returned to either their same position or to an equivalent position. So they have the right to be reinstated even if the employee has been replaced. So if an employer is looking at this role and they're saying, we can't leave this job vacant for 12 weeks, so they replace that employee, or if the job was restructured to accommodate the employee's absence. So if an employee's job is broken into pieces and those duties are picked up by other people within the organization, the employee still has the right to be reinstated in those situations. So the FMLA does not require or does not entitle a reinstated employee to any more rights or benefits than those to which they would have been entitled if FMLA hadn't occurred. So basically, an equivalent position is one with the same pay, benefits, and other terms and conditions of employment. So virtually identical to the employee's former position. It's got to have, substantially similar duties and responsibilities in order for it not to be some sort of demotion, because that's what you are looking to avoid. You don't want an employee coming back off FMLA and finding out that they've been demoted, they don't have the same duties, they don't have the same role, or maybe they've been demoted to a position where they don't have some type of benefit that they had previous to the FMLA leave. So you really are looking to avoid that. There are some situations when reinstatement is not required. So if an employee's employment is terminated due to layoff during the course of taking FMLA, be careful not to target this employee with a layoff, but if this employee works in a segment or group that was laid off, they are not protected by FMLA and a layoff situation. Another situation when reinstatement is not required is if there's been a shift change. If a shift has been eliminated or overtime has been decreased, an employee is not entitled to return to work that same shift or original overtime hours once they're restored. An employer can deny reinstatement if it's the end of an employment term. So if there was a contract of employment in place and it was due to expire during the term of the FMLA, they do not have to then reinstate that employee. They can also deny job restoration if an employee refuses or fails to provide that fitness for duty certification. So if you followed all the requirements to be able to properly request that from an employee and they either don't want to or won't for whatever reason, employers can deny job restoration in that situation. And then it's also if it's a physical impossibility. So this doesn't mean there's a disability involved. This means where it's physically impossible for an employee who is on intermittent or reduced schedule leave to begin or end the work during the middle of a shift. So if there's, I'm kind of blanking on an example, but if it's not possible for an employee to just come in at the middle part of the day and work the remainder of that day, the employer is not required to reinstate the employee on that basis. So there's a number of situations when reinstatement is not required. There can be some really finicky requirements here. So if you are contemplating refusing reinstatement, it might be worthwhile to run that by counsel before you make that decision.
So next we'll turn toward the FMLA's relationship with the ADA. So most of you probably know the ADA, which refers to the Americans with Disabilities Act, and the ADA Amendments Act is a federal law that applies to employers with 15 or more employees. And ADA leave is a form of reasonable accommodation needed by an individual due to an impairment that substantially limits a major life activity, or if there's a record of, meaning a history basically, of a substantially limiting impairment. And an employer must allow an employee with a disability to use accrued paid leave and to obtain additional unpaid leave for reasons related to a disability unless doing so would result in undue hardship to the employer. And that undue hardship standard really means something significant, significant difficulty or expense in accommodating a disabled employee. And that must actually be very significant for the EEOC to recognize an undue hardship. So in Minnesota, this law actually under the Minnesota Human Rights Act would apply to employers with even just one or more employees. So you'll want to keep that in mind to look at your individual state laws in addition to federal laws to avoid any disability discrimination claims. But this type of leave might be needed as a reasonable accommodation for an employee who has a disability so that they can attend medical appointments or get medical treatment so that they can recover from an illness or episodic manifestation of a disability. They may also need this leave to receive disability-related training, for example, how to use a service animal, or to make repairs to equipment or devices like an accessibility vehicle. And under the ADA Amendments Act of 2008, the definition of a disability shall be construed in favor of broad coverage and should not demand extensive analysis. So the definition of a disability is much easier to meet.
And so with that background of the ADA and the state-specific ADA type laws, I'm just going to touch on this here because the intersection of FMLA leave and ADA leave is really important. And where it typically comes up is if you have an employee that's exhausted all 12 weeks of their FMLA leave, but they have not been cleared by a doctor to return to work, it's possible the employer may have to provide additional unpaid leave as an accommodation under the ADA. So if a company is, even if you're not subject to FMLA or ADA, still be aware of potential disability discrimination issues under state-specific laws. But there's a lot of times I've read policies in handbooks that have a hard cap on leave time. These are called no-fault leave policies. And so what these are is statements that if the employee does not come back within X number of days after all of their FMLA time is exhausted, they're terminated. I've read those many times in my time here at my HR Council, and those can actually be disability discrimination, because if an employee has a disability, they cannot come back to work. Unpaid additional leave can be a reasonable accommodation. So if you have an employee that's out on FMLA leave and they come back and say, I'm just not ready to come back, what you have to do is engage in the interactive process under the ADA. And it sounds like a complicated term, but interactive process means sit down and talk to this employee. Ask them, what's going on? How can we help you? What might you need so that you can come back to work? If the need for further accommodation isn't obvious, you can request to get documentation from a medical professional that the employee does have a disability under the ADA and that they need an accommodation. Some of these can be, like I said, unpaid leave. They could also be working from home, working a reduced schedule, getting a standing desk. There's a number of accommodations that can apply here, but you want to make sure that you explore all options, including additional unpaid leave. One of the things that's come up recently with this law is there have been a couple of circuits that have put caps on this. There have been employees out there, for better or worse, that have been using this additional unpaid leave under the ADA as a way to get endless medical leave. And some courts have said that's not really what the purpose of this is. It's really meant to be just an additional leave and not that it's unending, because at some point this type of leave can cause obviously undue hardship. These are employees that you need to have around, and if it's becoming too much of a burden, it's possible that you may need to cut that off at some point. But don't do that without engaging in this interactive process and having a very frank discussion with your employee about what you're needing and what they need as well. So just one final point, like I said at the beginning, this is really something, and Britt will agree with me, just to jam this into a 45-minute presentation doesn't really do it justice. But if you have questions, we are always available 24/7. Contact us. Here's the email address, phone numbers, and our web address as well. Let us know how we can help you. These issues are complex, and unfortunately damages can be very high, even for relatively small employers. So we thank you for being with us today for this presentation, and have a great rest of the day. Okay. I think I just closed out.